English shorthand 120 words per minute. Legal passages. Book code LPB-1 of National Shorthand School Vizag. Passage number 24. It is in continuation of passage number 23. Please get ready. Start. 9. The tribunal, in a somewhat oblique manner, upheld the contention of the state of Andhra Pradesh and the Union of India that there is no provision for reservation in the Indian Administrative Service Appointment by Selection Regulations 1997 or the Indian Administrative Service Recruitment Rules 1954. 10. Feeling aggrieved, the petitioner preferred writ petition number 18,563 of 2011 in the High Court of Andhra Pradesh. By its judgment and order dated 20th February 2014, the High Court dismissed the writ petition. 11. The High Court did not even advert to the Indian Administrative Service Recruitment Rules 1954 or the Indian Administrative Service Appointment by Selection Regulations 1997, but in a rather cryptic manner rejected the case set up by the petitioner. The High Court held as follows. 7. The facts are not in dispute, as on the date of committee constituted for selecting non-Indian Administrative Service cadre from various departments. The petitioner were eligible to be considered. The main contention of the learned counsel for the petitioner is that the case of the petitioner has to be considered under office memo dated 3/12/2013, wherein the persons with disabilities have to be given preference in 3% reservation on the total number of vacancies in the cadre strength. But in view of the fact that the decision of the Honorable Supreme Court and the amendment of office memo dated 29/12/2005 is prospective, that amendment cannot be retrospective to the petitioner to consider his case under 3% reservation of Persons with Disabilities Act. Therefore, we do not find any merit in this writ petition and it is liable to be dismissed. 12. Subsequent to the decision of this court, the Union of India issued another office memorandum dated 3rd December 2013 and inserted the following paragraph. Reservation for persons with disabilities in Group A or Group B post shall be computed on the basis of total number of vacancies occurring in direct recruitment quota in all the Group A post and Group B post respectively in the cadre. 13. A perusal of the impugned judgment and order indicates quite clearly that the decision of the High Court was based on completely different grounds than the decision of the tribunal. In fact, the reasons given by the tribunal were not even remotely adverted to by the High Court. 14. Be that as it may, feeling aggrieved by the decision rendered by the High Court, the petitioner is now before us. The primary contention urged before us is that in view of the decision of this court in National Federation of the Blind read with section 33 of the PWD Act, the petitioner is entitled to the benefit of reservation for persons with disabilities in the matter of short listing for selection to the IAS. 15. We may note at this stage that the office memorandum dated 3rd December 2013 and more particularly the inserted paragraph mentioned above came up for consideration before the Delhi High Court in H.C. Sharma versus NDMC. The Delhi High Court took the view that the inserted paragraph was contrary to the conclusions and directions in National Federation of the Blind. Accordingly, the said paragraph was struck down. 16. Be that as it may, the decision of the High Court in H.C. Sharma came up for consideration before this court, and on 18th December 2014, leave was granted to challenge the decision. The civil appeal arising therefrom, being CA number 11,895 of 2014, is pending and has been tagged with CA number 87,295 of 2012, State of Haryana versus Viklang Sangh. 17. Under these circumstances, we are of the opinion that apart from the fact that this petition raises questions regarding the interpretation of Section 33 of the PWD Act, read with the Indian Administrative Service Appointment by Selection Regulations 1997 and the Indian Administrative Service Recruitment Rules 1954. This petition also relates to the interpretation of the Office Memorandum dated 29th December 2005 and the Office Memorandum dated 3rd December 2013. Since all these issues are interlinked with the pending civil appeals, we are of the view that for a comprehensive decision in the matter and to settle the controversy, it will be more appropriate if leave is granted to the petitioner, and this matter is tagged along with CA number 7295 of 2012 and CA number 11,895 of 2014. 18. Accordingly, we grant leave and tag this appeal with CA number 7295 of 2012 and CA number 11,895 of 2014, Madan B. Lokur, Judge,